Have you thought about or are you concerned about who would step forward for your child as guardian if something happened to you? So recently I did a YouTube video on what to consider when naming a guardian. And so many people ask, well, what do you do if you're afraid that someone will step forward or there'll be some kind of conflict with someone who you would never want to serve as the guardian for your child? Is there anything you can do? And what can you do? It's a really great question, and I'm going to be covering that today. My name is Laura Croft, Law Offices of Laura Croft, Timeless Estate Planning. Subscribe here if you're a parent looking to name guardians or looking for additional practical advice with estate planning. So, yes, the question is, can we do anything if there's someone out there who you would never want to serve as guardian for your children? Now, last video, we talked about what are the things that we should consider when naming a guardian, whether it's financial stability, location, emotional connection, religion, values, culture. There's just so many things that are important to you that we should be considering, but also there are steps we can take to ensure that if a person should never serve as guardian, we are excluding them. So I call that a confidential exclusion. What does that look like? Why would that come up? What could your scenario be? I've seen a very wide range of scenarios. I've seen situations where there's a very unstable, maybe it's a friend, maybe it's an auntie. There are some times where it's mainly just there's family conflict and things that maybe nobody else knows about. Certainly a judge would not know about unless we had it documented. There's been extreme cases where there's a fear that actually someone's in jail, and the biggest fear is that they'll get out of jail and come in for guardianship. Or it might be where I had this scenario recently. I was talking to someone and she was telling me her greatest fear in life was that her mother would step in for guardianship. And I said, why? Why is that a fear? Tell me more. And her mother had mental illness and was living, she was homeless at the time. And this was this woman's fear. And I said, to take control of it, to make sure that we're looking that fear straight in the eyes and actually taking practical action to ensure that that person never steps forward. We can do that, but you actually have to take it within your control. You have to take action. So what we do is it's called a confidential exclusion. That person does not need to know that you never want them to take care of your child, right? Of course, that could create more conflict that you don't necessarily need, but it's a confidential exclusion. And when we do guardianship planning, yes, we name guardians in your will. That's where you would typically find them. But we also do quite a few additional, actually 8 additional documents that are all part of, we call it a kids protection plan. It is a very comprehensive approach to guardianship. I have 4 minor children myself. I've looked at where all the holes in traditional estate planning are. I've looked at where all the holes in traditional guardianship, lie, and created a plan to fill those holes, right? So one of those holes is this issue of, what if there's somebody we want to confidentially exclude? What that means is that if it goes before a judge and this person steps forward, in that kids protection plan is a confidential exclusion of that individual. We're making it clear. It's been signed. It's been notarized. It's a legal document setting forth in clear terms that that person is not someone who is suitable or just clearly not someone who you choose to serve as guardian. So if you found this helpful today, that's great. If you're ready to confidentially exclude someone, please reach out to us so we can help you get started. And for more estate planning advice, like, subscribe, comment below, and we hope to see you at the next video.